Hello and welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal news from 3rd October to 8th October 2022. In first important news, the Supreme Court has held that a married daughter cannot be said to be dependent on her mother in cases of compassionate appointment. In the case of State of Maharashtra versus Ms. Madhuri Maruti Vidhate, the Supreme Court has held that a married daughter cannot be said to be dependent on her deceased mother and therefore is not eligible for compassionate appointment. The court has further said that the whole object of granting compassionate appointment is to enable the family to tide over a sudden crisis. The object is not to give such family a post, much less a post held by the deceased. In second important news, the Supreme Court has held that court can undertake preliminary inquiry under Section 11 of the Arbitration and Conciliation Act to ascertain if the dispute is arbitrable. In the case of MR India Limited versus Tarun Agarwal Projects LLP, the court has held that under Section 11 of Arbitration and Conciliation Act, court can undertake preliminary inquiry to ascertain if the dispute is arbitrable or falls under the accepted category in the agreement. The court has also referred to the landmark case of Vidya Drolia versus Durga Trading Company and IOCL versus NCC Limited. In third important news, the Supreme Court has held that dependents are entitled to compensation even if they inherited the business of the deceased while considering motor accident claim. In the case of K. Ramya and others versus National Insurance Corporation Limited, the Supreme Court has held that dependents are entitled to compensation for loss of income even if businesses and properties of the deceased were bequeathed to them. The court has further held that compensation under Section 168 of the Motor Vehicles Act must be fair, reasonable, and equitable. The court has held that Motor Vehicles Act of 1988 is a beneficial and welfare legislation that seeks to provide compensation as per the contemporaneous position of an individual, which is essentially forward-looking. Lastly, the Supreme Court has held that terms of invitation to tender are not open to judicial review except in a few cases. In the case of Airports Authority of India versus Centre for Aviation Policy, while considering the scope of judicial interference under Article 226 of the Constitution of India, the Supreme Court has held that the terms and conditions of the invitation to tender are within the domain of the tender-making authority and are not open to judicial scrutiny unless they are arbitrary, discriminatory, or malified. This brings us to the end of our weekly legal update. If you like this video, please like and share and subscribe to our YouTube channel.